Okay, we're still on legal influences. Yay, they keep going. Okay, so we're up to looking at work health and safety and workers' compensation. Again, Simpsons clip attached. They are fun, but they also, I don't know, they give you something. Okay, yes, this is another video that is attached to give you an outline on what work health and safety is all about. Yet again, I'm reminding you, please go to the Google Classroom version of the PowerPoint and watch the clip. Okay, so work health and safety. Under the Work Health and Safety Act of 2011, New South Wales, when you see New South Wales in brackets, that means it's a state law. Employers must ensure the health, safety and welfare at work of all employees by providing a safe system of work, ensure that plant and substances are used or handled, stored and transported safely, and provide employees with necessary training. Again, another clip is attached. The clips are attached because they can give you more examples so that you understand what we're talking about. Okay, what are the employer requirements under work health and safety? Okay, so work cover must be informed of any deaths or serious injuries in the workplace. These things have to be monitored and there's a centralised place to do that. It's called work cover. Okay, employers must take out workers' compensation insurance. This means that if somebody is hurt or even killed on a job site or business premises, an employee, that their medical bills and or money is given to their families in the event of death if something should happen to them at work. Okay, employers must also take steps to ensure people on site are not exposed to risk. Remember, they have to provide a safe work environment. They must take reasonable care for the health and safety of others. Committees must be established at workplaces with more than 20 employees. So, for example, there is more than 20 employees at Bulladilla Central School. So we have a Work Health and Safety Committee that meets, I can't remember how often they meet, but they meet on a semi-regular basis just to go over any issues that might be happening around the school. That could mean looking at something in the playground that is damaged or broken that could cause injury in a classroom. There are death traps everywhere. The last one is work cover may inspect the workplace. So work cover can at any time request to come in and inspect a workplace to make sure that work health and safety initiatives are being undertaken in a business. Okay, workers' compensation is controlled by the New South Wales government agency called Work Cover. All employers must take out a policy with a licensed insurer. We just talked about this. There has recently been a strong focus on getting injured employees back to work as soon as possible. The Workers' Compensation Amendment Act of 2012, New South Wales state law. The 2012 changes by New South Wales Government to Workers' Compensation Scheme cap payments for injured workers. This has not necessarily been celebrated by unions and employee groups. They removed journeys to and from work from the scheme. Again, not a celebrated change. Once was that if you were injured while you were travelling to or from work, you were covered under workers' compensation. That no longer exists. Stop families of workers killed on the job from being compensated. Now, I did say before that they did receive some funding, but that has been greatly limited, reduced, almost to virtually nothing these days. Clip is attached for you to have a look at some of these changes and reactions to them in the Workers' Compensation Act. The Workers' Compensation Legislation Amendment Act 2018. Okay, so these newer laws restore the jurisdiction of the Workers' Compensation Commission to determine all disputes, including the review of work capacity decisions, effectively creating a one-stop shop for dispute resolution. What does all this mean? It means that those last lot of changes that I just spoke to you about, as I said, not happy, not happy, not happy, people go and vote, governments and policies change. Okay, because people were not happy with the 2012 amendments, in 2018, workers' compensation legislation was revisited and some changes for the positive were placed. Okay, so what does this Workers' Compensation Commission, blah, 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 do? Okay, the Commission will have the power to determine permanent impairment disputes without referring the dispute to an approved medical specialist. This may reopen the door to compromise settlements of lump sum claims where there are competing assessments of the degree of permanent impairment. So, not a perfect system, but better than what it was in 2012. Another major change will simplify the definition of current weekly earnings and remove the current exclusion of overtime and allowances from earnings after 52 weeks of weekly compensation payments. So if somebody is injured and getting paid overtime and allowances, if they have been receiving those, let's say, for 12 months prior or 52 weeks, these type of payments will be included in their compensation payouts. Okay, so common law redress. What is this? This is when we go before the judge. So employees may take legal action against an employer when the employer or another employee has been negligent or breached their duty if the employee has a permanent body impairment of more than 15%. Employees may not claim both damages at common law and lump sum compensation for permanent impairment under statutory law. Okay, so if you are injured at work and that injury results in you losing function of 15% of your body, you have two ways you can go. You can go for the lump sum compensation payment through work cover, or you can take it to court and sue the person responsible. Potentially you could be getting more if you are going the common law route, but then again there's not always a guarantee that you're going to win. So people that are in that position have to really weigh up which way they want to handle it. Okay, anti-discrimination. Okay, so the Fair Work Act does have some elements of discrimination law built into it, but as I said before, it does also come down to the state's laws as well. So the federal law doesn't cover everything, but it does make it illegal to discriminate against a worker based on a personal characteristic that is irrelevant to the performance of the work, such as race, age, gender, or disability. Strategies that are used by business to eliminate discrimination include committing to a workplace free from discrimination. It would be very foolish for any workplace to publicly declare that they were not doing this in this age of social media, viral internet sharing, automatic transmission of information. It could damage a business's reputation to quite a strong degree if they were to come out and go, oh no, we discriminate. Okay, other things that businesses do: writing and communicating policies to prevent discrimination, including a code of conduct. The Department of Education has a code of conduct that teachers must follow. As most of you know, I'm the Anti-Racism Contact Officer at our school. That is a position that is at every school to stop certain forms of discrimination happening in the workplace. Making sure all policies and procedures are clearly documented and accessible to employees. Training managers and staff in cultural diversity issues. And appointing a grievance officer and specifying grievance procedures. A grievance officer is if you feel you've been discriminated against, that is the person in a workplace similar to my position at school as ARCO. You go and see that person and they have specific procedures that they have to follow after an incident has been reported to them. Equal employment opportunity. This refers to equitable, equal, policies and practices in the recruitment, selection, training, and promotion of people. So, for example, the Affirmative Action or Equal Employment Opportunity for Women Act of 1986 was brought in by the Commonwealth Government to make sure that women were treated fairly and equally at work. This legislation exists. We also know that there is still a gender pay gap. So while the legislation exists, it is still not a perfect world, and so these issues still remain really quite important. Now, the benefits of having an equal employment opportunity or affirmative action happening in the workplace, it ensures that the best person for the job is chosen. You may have heard reference to a term like the boys' club. The boys' club suggests that some perks are had if you're, I guess, friends, that men that went to school with each other would employ one another for their jobs because they had the old boys network. It didn't mean that their mate or their friend was the best person for the job, just that, oh, I know him and I like him, so let's give him a job. Another benefit is that the business gains the person with skills and abilities most appropriate to its needs. So again, that's the best person for the job, not the person you're already friends with. A more positive work environment is promoted when you see that everybody is given a fair and equal go. It means that you too, in your position in a job or in a business, should expect that you would also get a fair and equitable go. Attached is another clip looking at equal employment opportunity in business. Okay, so let's have a look at an old HSC question. Well, 2013. All right, so full-time permanent employees in Australia are generally entitled to 4 weeks leave, 4 weeks of annual leave. What is the legal basis for this? Does this come under common law, industry awards, national employment standards, or work health and safety legislation? Just give you a second to think. I hope you've chosen. The answer is C, national employment standards. Okay, that is the last slide on that one, and that is the end of the legal influences on human resource management.